In this installment, Maneet Sadhra is being interviewed by Gaspard Galati on the topic of non-disturbance agreements.
Jumping right in, Maneet, can you tell me what a non-disturbance agreement is?
Sure, Gasper. Non-disturbance agreements, or NDAs, are agreements that come up in the context of secured lending, where you have a tenant leasing a property that has a mortgage on it. An NDA helps create certainty about what happens to a lease when a landlord defaults on its mortgage and the lender forecloses on the property. I'll break down exactly what an NDA does. So, a lease creates a contractual relationship between a landlord and tenant, and the various loan documents create a contractual relationship between the landlord and lender. But without an NDA, there is no contractual relationship between the tenant and lender. An NDA creates that direct relationship between the tenant and the lender. It sets out the rules for what happens to the tenancy if the landlord defaults under the mortgage and the lender takes possession or forecloses on the property.
What happens to a lease if a landlord defaults on its mortgage and the lender takes possession of the property without an NDA?
Unfortunately, it's not a simple answer. What happens to a tenant's lease in this scenario will depend on the priority of the lease or the mortgage. If the tenant's lease has priority, then the lender has to abide by the terms of the lease. If the mortgage has priority, then the lender doesn't have to abide by the terms of the lease, and the tenant might lose the benefit of its lease.
Makes sense. How would you determine who has priority?
We could spend hours on that topic, but today we'll keep it simple. If you have both a notice of lease and the mortgage registered on title, you can determine priority based on the dates that the notice of lease and mortgage were registered. But if a notice of lease is not registered on title, then the question becomes whether the lender had actual notice. If there was actual notice, then the lease has priority.
Do lenders and tenants ever want the lease to continue?
Often, both parties want the lease to continue. Making sure the lease continues can help everyone have certainty going forward. Without agreement between the lender and tenant, there can be unintended and negative impacts on both parties. For example, the lender may want the lease to continue since the rent provides an income stream to repay the mortgage debt, and a tenanted property might be more valuable to potential purchasers. And on the flip side, the tenant may want to preserve the lease for various reasons. The tenant may have invested a lot of money into the premises. The tenant may have a substantial income loss if it has to relocate. The tenant may want the lender to honor any special provisions or rights contained in the lease, such as signage rights. So, to mitigate future risks, one of the best ways for the lender and tenant to make sure the lease continues is to enter into an NDA.
It sure seems that entering into an NDA is a win-win proposition for both the tenant and the lender.
Absolutely. NDAs provide both parties with clear expectations about what happens if the lender steps into the shoes of the landlord. But it's important to remember that you still have two competing interests, that of the tenant and the lender, which need to be balanced. For example, the tenant will want to ensure that it will not be deprived of the benefits of the lease that it has bargained for. The lender is going to want to remove itself from certain aspects of the landlord-tenant relationship. For example, the lender may want additional notice and cure rights beyond those provided in the lease.
So I guess the takeaway is that a carefully drafted and negotiated NDA is key.
Definitely. A carefully negotiated NDA is a great way to help provide lenders and tenants with the certainty they need.
That was Maneet Sadhra in conversation with Gaspard Galati on the topic of non-disturbance agreements. If you would like to learn more, contact Maneet on our website, dv-law.com.
This audio recording was a general discussion and should not be relied upon as legal advice.